It's not cool when our nominees don't take it upon themselves, if the White House doesn't encourage it, to go sit down with the senators. It's not fair. It puts us in a horrible position. It's disrespectful. You're going to be appointed, if you're confirmed, to one of the most powerful jobs on the planet. And that's not an exaggeration. You have a lifetime appointment. And I wish you'd deliver that message. Counselor, you're at Butler Snow?
Yes.
Your partner?
Yes. So.
Okay. It's a good law firm. I have some experience with our Department of Motor Vehicles in Louisiana. I spent a year there one time trying to get my son's lost license renewed. I remember all they had, I didn't bring any reading, and I remember all they had were copies of Popular Mechanics from like 1997 or something to read. Our problem in Louisiana is our employees there are good. It's our politically appointed managers. I was asked one time, how many managers do we have how many managers work at our Louisiana Department of Motor Vehicles? And I said about half. Let me ask you a couple of questions. First, you do I understand your participation in Boys and Girls Club? Tell me about that briefly.
Thank you, Senator, for that question. So as a youth, I grew up. That was like my home away from home. From the time I was 9 years old till I went off till I went to college. To college.
It's a really good organization.
Absolutely.
Every year or two, Mr. Denzel Washington, who's one of the 5 coolest people on the planet, comes up here to lobby for money, not for himself, for Boys and Girls Club. So I've had a chance to get to know a little bit about it. You worked at well, let me ask you this. Do you think America is mostly good or mostly bad?
Thank you, Senator, for that question.
You're welcome.
I believe that America is the greatest country in the world. I don't know in any other country where I could be in this position to come from where I've come from and be in a position to be nominated to the Sixth Circuit and be speaking to senators. I could have never imagined this happening. And maybe it happens in other countries, but it's the greatest country in the world to me.
I agree with you. Look, I don't know whose fault it was, but you may want to go back and talk to your friends at the White House. It's very unfortunate that Senator Blackburn and Senator Hagerty didn't have a chance to sit down with you. And I don't want to get into whose fault it was, but it's the White House's job to make sure that happens, if they really care about what we think. And I gave this same speech to employees at President Trump's White House as well. For a while, my experience with some of the people in charge at the Trump White House was different from Senator Durbin's. I was brand new, and their attitude toward me was pretty cavalier. It was just sort of sit down and shut up. And it's not cool when our nominees don't take it upon themselves, if the White House doesn't encourage it, to go sit down with the senators. It's not fair. It puts us in a horrible position. It's disrespectful. You're going to be appointed, if you're confirmed, to one of the most powerful jobs on the planet. And that's not an exaggeration. You have a lifetime appointment. And I wish you'd deliver that message. Tell me in the few minutes I have left, tell me that your work, well, let me try this. It's been suggested you don't have any experience. okay? And you don't have the experience to be on the Court of Appeal. Can you address that? Tell me what your answer is to that.
Thank you, Senator Kennedy, for that question. Throughout my career, I've handled 23 appeals to conclusion. I have one matter pending before the Sixth Circuit. In the vast majority of the appeals that I've handled, I have been the primary drafter of the appellate briefs. I've argued 10 cases to the Tennessee Court of Appeals and the Tennessee Court of Criminal Appeals. I have not argued a case to the Sixth Circuit. Additionally, I have significant trial experience, having tried 19 cases in federal court and state court. And that doesn't take into account I've litigated hundreds of cases. And as you know, some cases are sometimes resolved by settlement, some by dispositive motions. So I have that experience as well.
Okay, I'm over time. Thank you, Mr. Chairman.
And congratulations, Mr. Mathis, on your nomination. I want to start by adding my voice in support of Senator Blackburn and Senator Haggerty, and saying that I hope that the process has been followed in this nomination will never be the process again. But I also want to point out that this seems to be a more systemic issue in the sense that Senator Sullivan, who's not a member of this committee, as the chairman knows, Senator Sullivan Malaska, has been unable to meet with any Ninth Circuit nominee who would be judging cases from his state for the entire past year. He has asked repeatedly to sit down with Ninth Circuit nominees. He's not a member of this committee, doesn't have the benefit of being able to ask questions here before we vote on them. He'd like to meet with them. And as of December, for months on end, he was unable to just ask questions of the nominees, and for that reason has been voting no on nominees he might otherwise be willing to support or at least to consider. And I just don't understand it. I don't understand why it's not possible, why this White House is denying senators the ability to meet with nominees, engaging in basic consultation. I don't get it. I guess it's just a no holds barred, burn all before you strategy. But I have to say, I think it's one that's going to backfire, and I think it's unfortunate. Mr. Mathis, that really doesn't have anything to do with you personally. So I'm sorry that you've had to sit through all of this, because it's really not about you. But I agree with the chairman to the extent that I think these are important issues, and I hope ones that we can get resolved. But let me ask you some questions about your own record. Let me ask you about a 2007 law review article. Were you in 2007? Had you graduated? Is that the year you graduated from law school?
That is the year.
So in this law review article, maybe you wrote it while you were in law school. I'm not sure about the timing, so maybe you remember. But in any event, I want to ask you about it. You argue there that the Supreme Court ought to create a freestanding actual innocence claim when it comes to federal habeas petitions, which, as I understand it, would allow a convicted defendant, to be able to relitigate his case at any time if he alleges that he has enough evidence to prove his innocence. Have I got that right? Am I rehearsing your argument right there?
Thank you for that question, Senator. That article I wrote while I was in law school. It was published in 2007. I think I was still in law school when it was published. And the case that I was writing about was House v. Bell, which is a case that originated in Tennessee, which is why it was of interest to me. And there was two issues that the Supreme Court took up in that particular case. I don't recall what the two issues were, but the court found in Mr. House's favor on one of the issues, and therefore did not address the second issue.
And so do you continue to think, when it comes to the federal habeas procedure and creating a freestanding actual innocence claim, do you think do you still advocate that position? Is that something that you think is still a good idea?
Senator, since I wrote that article, and I've been practicing, I haven't written academic articles since that time.
Probably wise.
I'm sorry.
I said probably wise, but
yeah,
go ahead.
I've litigated a number of cases and hadn't litigated issues related to the freestanding innocence issue. So I hadn't litigated that issue and haven't advocated for that particular claim since I was in law school.
Well, I ask because I have concerns about that. That would be a very significant departure in federal habeas law, which would create, I think, a very significant new set of challenges for prosecutors, for those trying to bring these folks to justice. And so it concerns me. But it sounds like this is not something that you've continued to advocate. Let me ask you in my time remaining here about some of these questions of experience that you've been getting. And you just said, I want to be sure I understand. You've argued 10 different appellate cases. Those are in federal court or state court or?
Those were in state court.
And then how many circuit courts of appeals, federal courts of appeals, have you litigated in?
I've litigated in the Sixth Circuit.
Okay, just the Sixth Circuit? And you've not argued in the Sixth Circuit, is that right?
I have not argued in the Sixth Circuit.
How many appellate cases have you handled altogether in the Sixth or anywhere else, if you had to put a number on it?
23 to completion. I have one currently pending before the Sixth Circuit.
Okay. And to those who would say and have asked you about your record as an attorney, I know you've had a court kick back a filing because you didn't disclose what you're supposed to disclose. You mislabeled a brief for rehearing, had a court kick it back to you, and that, every attorney makes mistakes. But what would you say to those who say, well, his work sometimes a little sloppy, doesn't seem like there's a record here of courts sort of having issues with some of what the filings that he's given. What's your response to that?
Thank you, Senator, for that question. In any case that I handle, especially before appellate courts, I try to abide by the rules. You mentioned issues that were kicked back, one where I didn't do the PDF correctly, things of that nature. Those have happened. Of course, I correct those issues promptly, and none of those have prejudiced my clients, and there's been no issues with the briefs that I filed.
Yeah, fair enough. Great. Thank you, Mr. Mathis. Thanks for being here. Thank you, Mr. Chairman.